video of value addition series. In this video, we are going to discuss some of the important Supreme Court cases related to the ordinance, related to the anti-defection law, federalism, center-state relation, governor role, as well as the separation of power. So in this case, these 11 cases we are going to discuss. Let us start. The first case, which is related to the ordinance making power of president and the governor. The first case is DC Wadhwa case of 1986. In this case, Supreme Court have interpreted Article 123 and Article 213, which gives the ordinance making power to the executive, president and the governor respectively. In this case, Supreme Court said that the repromulgation of ordinance, repromulgation means when the ordinance is reintroduced without any amendment after its expiry. So when this kind of repromulgation is done again and again, Supreme Court said this is unconstitutional. Why unconstitutional? Because it violates the separation of power. Under the separation of power, lawmaking power should be under the legislature. Since through ordinance the executive makes the law, so it violates the separation power. Hence the ordinance should only be promulgated in exceptional circumstances, not in the ordinary circumstances to bypass the legislature. So this was the case related to the DC Wadhwa case related to separation of power and ordinance. Next important case is the Krishna Kumar case versus State of Bihar of 2017. In this case, Supreme Court reiterated the repromulgation, but in this case, Supreme Court gave a strong statement saying that when the repromulgation of ordinance is done without placing them before the legislature to bypass the legislature, it is the fraud on the constitution. Please mark this word. This is the fraud on the constitution. This strong statement given by Supreme Court. See, these two cases you can use related to the ordinance. Next important two cases are related to the anti-defection law. This anti-defection has been in the news recently in the Maharashtra case, that is Shiv Sena versus Shiv Sena. Also anti-defection laws were interpreted. There are two important cases. First is the Kihoto Hollohan case of 1992. In this case, Supreme Court said that they gave the importance of judicial review. It said that the speaker's decision comes under the judicial review. Second, speaker works as a quasi-judicial body. Hence, speaker should follow the PNJ, that is the principle of natural justice. So, speaker should follow principle of natural justice in the when the speaker is deciding cases related to defection. Next important case is the Manipur Legislative Assembly case of 2020. The actual name of this case is Chandra Singh versus the Honorable Speaker Manipur Legislative Assembly and others 2020. You can use this also saying that the Manipur Legislative Assembly case of 2020. In this case, Supreme Court said that speaker should give its decision at the reasonable time frame. It should not keep the decision for the infinite period of time. They should give the decision within a stipulated time. The second thing reiterated that the role of speaker in this case of anti-defection law is quasi-judicial nature. Hence, in this case, Supreme Court suggested to replace the role of the speaker with an independent tribunal headed by retired judge of Supreme Court. Okay, so these are the things, two cases important for anti-defection law related cases you can quote. Next important case is related to federalism, center-state relation and the role of governor. In this regard, SR Bommai case of 1994 is very important. Here in this case, SR Bommai case, Supreme Court had discussed about the importance of cooperative federalism and said that federalism is a part of basic structure and cooperative federalism is very important. Next important thing which Supreme Court have discussed is about Article 356. Article 356 should be used in the extraordinary situations, and in this case Supreme Court gave the important limitation and scope of Article 356 and gave when the Article 356 can be considered as the proper use and when improper use. Those guidelines also has been given by Supreme Court in SR Bommai case of 1994. Next thing is discussed is the President order or the Governor order and President order under Article 356 is under the judicial review. So it is not immune from the judiciary. It can be reviewed by the judiciary. Next important thing, importance of the floor test, that is whether the government is having the majority or not should be tested at the floor of assembly. It should not be based on the subjective opinion of governor. So this is very important landmark judgment of Supreme Court, that is SR Bommai case 1994. Next important case is Nabam Rebia case of 2016. This is the recent case where Supreme Court have given the role of governor should be politically neutral. So they should follow the political neutrality. The second thing Supreme Court said that the discretionary power mentioned in the Constitution should be used for the fair nature, not to advance the personal or the political motive. That should only be used wherever there is necessity as per the provisions of the Constitution. Secondly, the aid and advice of the governor, aid and advice of executive to the governor should be followed except in the special situations, that is the situation of discretionary power. Other than those cases, governors should be bounded by the aid and advice of executive. That was reiterated by the Supreme Court in the case of Nabam Rebia case of 2016. Next cases are related to the separation of power. In this, there are 5 important judgments which we can use. These judgments can also be used about the appointment related issue of the Supreme Court and High Court judges. The first judge case, also known as the SP Gupta case of 1981, here Supreme Court had said that the consultation, that is President under Article 124, President have the power to appoint the Supreme Court or High Court judges with the consultation of Chief Justice of India. In this case, Supreme Court said that the consultation does not mean concurrence. That means the consultation or advice given by CJI to the President regarding the appointment of Supreme Court or High Court judges is not binding on the President. It is just the consultation, not concurrence. However, in the second judge's case of 1993, also known as the Supreme Court Advocate on Record Association versus Union of India, Supreme Court said that the consultation means concurrence. That means the consultation or the advice given by CJI to the President will be binding on the President. So, advice tendered by CJI is binding. Next important case is the third judge's case of 1998. Here Supreme Court said that the recommendation or the advice should be given, consultation should be given by plurality of judges, not just by the CJI. Plurality of judges means there should be 4 senior most judges making the collegium, and that collegium should give the advice to the President, and that advice should be binding on the President, and based on that President should appoint the High Court or Supreme Court judges. So here comes the formation of collegium system in Indian judicial appointment system. However, there were a lot of criticism of collegium system, especially on the wake of lack of transparency in the system. To resolve that, the Parliament brought 99th Constitutional Amendment Act and the NJAC Act. However, this 99th Constitutional Amendment Act was challenged in the 4th judge's case of 2015. The case name is Supreme Court Advocates on Record Association versus Union of India of 2015. Here Supreme Court declared that 99th Constitutional Amendment Act and NJAC, that is the National Judicial Appointment Commission Act, is unconstitutional. Why? Because it violates the independence of judiciary, which is the basic part of the basic structure. So in this case, Supreme Court reiterated or reinforced the importance of judicial review and doctrine of separation of power. However, in this case, Supreme Court acknowledged that there is a need of greater transparency and suggested improvement within the collegium system. So these 4 cases are related to the appointment of Supreme Court or High Court judges. Along with that, one important case is related to the independence of judiciary or the separation of power is L. Chandra Kumar case versus Union of India case of 1997. In this case, Supreme Court has said that the tribunal should not be the replacement of high courts. They should be the supplementary institution of the high court and should work under the supervisions of the high court. They cannot be considered as the parallel institution of high court. As we know that the tribunals are formed under the Article 323A and Article 323B, and these tribunals contain both judicial members as well as the executive members to in the decision making or the judgment making procedure. So that violates the independence of judiciary that is set by the Supreme Court in L. Chandra Kumar case. Okay, so that should not be replacement of High Court. So this is the case which is related to the separation of power between the judiciary and executive. So these are the important cases related to the Supreme Court judgments related to Ordinance, Anti-defection law, Federalism, Center-State relation, governor role, separation of power. Thank you so much.